Governance by Judiciary into the Next Millennium, Rajeev Dhavan. In the inevitable chemistry of the social change, judges are certainly not anti-catalyst. Justin Krishna Iyer, 1969. Written in 1969, Justin Krishna Iyer's remonstrance that judges were certainly not anti-catalyst in the path of India's progress, captured both the politics of the present and the prophesied as a promise for the future. As an institution of government, India's judiciary was born in 1950. Why? And through the new constitution, its creation was a distinct break from the past. The imperial judiciary of the British had served its masters well. It had brought a sprawling empire under the sovereignty of an occidental rule of law, empowered it to support the law and order needs of the Raj, subordinated the person and customary laws of diverse peoples into a governable coherence and self behind an aura of law, justice, court of for the natives to whom governance was to be transferred. In Nehru's immutable words on the stroke of midnight of the 14th August 1947, whilst the rest of the world slept, India's constitution makers did not know what to do with the judiciary. British courts were to remain, partially out of reverence and partially because they were convenient and familiar. That part was easy, but the retention of British court did not engage the more serious question of constitutional politics over the political role of the judicial power to protect people from their democratic masters. In an imperial state, the judiciary was simply an adjunct to imperial governance, an autonomous bureaucracy which was fair but not entirely independent. In its aim and perspective, that the British had designed a slightly more enlightened judicial model for its own people is irrelevant. The question before independent India was, would India's future constitution create a new post-imperial judiciary which would reinforce its democracy, interrogate majoritarianism, protect governance from the innumerable biases of governance, and empower people to pursue their version of good life within the framework of commonweal. If such a creation was to be institutionally embedded in the constitutional structure, it would have a far more significant role than any imperial judiciary could have ever possessed. There were too many dozens and demons in the cupboard. Warnings from the everywhere. Nehru's Fabian instincts, learned from the Lasky and other, warned that judges were anti-labor and fueled by vices in favor of the propertied class. There was a long line of instances from the truth of the century confirming his worst fear. America's record had been no better. The American Supreme Court's turn of the century record was buttressed by the liberal voice of Holmes or Brandels. America's New Deal crisis with the President Roosevelt's threat to pack the judiciary, coupled with the advice given to B.N. Rao, the Constitutional Assembly's constitutional advisor, the judiciaries can stand in the way of regulatory welfare state progress, scale the fate of the future judiciary. Judges were alright, but not entirely to be trusted. The djinns and the demons remained committed to Bill of Rights, and the judiciary became the custodian of enshrined fundamental rights. Confronted with the federal design, it had to be left to the judiciary to interpret the federal allocation of powers and perforce determine federal disputes. This later task had already been entrusted to the Federal Court 1937 to 50 with a relatively unobtrusive result, but in fact the custodianship of the fundamental rights and arbitration of disputes within the federal system itself instituted a dramatic transformation of the Indian judiciary in the emerging constitutional system. It meant that the higher judiciary had a power which no British or common law judiciary outside America had even claimed since the 17th century. It was an enormous power empowering India's new judiciary to strike down government decisions and parliamentary statutes because the judges thought that they were unconstitutional. This was an American-style judiciary with the American-style powers. The djinn and demons returned. All kinds of changes were made in the constitutional text. The due process clause were converted into any procedure clause. This means that it was not for judges to lay down a due process of their on choosing, but simply to follow the one laid down by legislature. Each article of the Bill of Rights were written and rewritten so that the power of the government and the legislature trimmed. To leave as little room for ambiguity as possible, the biggest debates were overdue process, property rights, and the social welfare provisions. Protests were observed. As far as the managers of the Constitutional Assembly were concerned, the future judiciary had been neutralized, nipped in the bud. Modern in its design, India's judiciary was to play a secondary role and adjunct to the new state, but never quite to be its masters. But one more step had to be taken before the digital demons could be confined to the lumber room. This concerned the power to appoint judges. This was crucial. Who was to make these appointments? So the range of the choices was limited. The English model was a political appointment model in which will of the prime minister and his cabinet prevailed. Informally, the judiciary had its say, even a decisive say in many instances. The American approaches world scenario confirmation around appointment. This was thought to be cumbersome. India retained the political model with the judiciary to be consulted. So what was created was a potential powerful judiciary, partially neutered by the constitutional text and partially controlled by the executive, in whose hands lay the appointment of the future judges to replace existing incumbent. Perhaps this is why Nehru held the view that the main qualification for a future Supreme Court judge was that he must have served in the High Court somewhere. Whether brought together in a single document or not, constitutions are expressed through innumerable texts designed to bring governance together. Constitutions potentially conceal the seeds of discord and divisiveness. The various texts create institutions, empowerments, and the process. Each institution or process attracts a power politics of its own, and to the working of the constitutions are educated custodian of various ranks and the empowerment of the differing shapes and size, each one vying for their own turf, though not generally unmindful of the whole. To the Maha or Grand Custodian of the executive and legislative power, who claim to be rulers of India, were added many others. Institutional rebellions and the processual hangs up take place in any constitutional system, not necessarily dramatically but often quietly. A million mutinies seem to take place all the time, and they are not really immunities, but the consist of the claims, demands, protests, refusals, inhibitions, and restraints. Delays, sometimes by minor functionaries, sometimes these are ironed out, sometimes overruled, sometimes crushed, sometimes simply left in the air to be resolved some other day. Constitutions are veritable hotbeds of controversy, inviting contention and division divisiveness. Amidst pleas of harmony, each custodian and each player in any institution or any process may play his own game, subjects to his own rules, while accepting the discipline imposed on him from some but not all quarters. Of course, constitutions are not always tested to the extremities of their impossible limits, but it is these tensions that make constitutional interesting, exciting, conflict driven, tested for the tensile strength, ingenuity, and sometimes unworkable. But the ones that endure develop practices to keep them together. These practices or conventions change over time, but without this institutional practice and the morality they portray, constitutions can fail, partially or even fully. Independent India has had its fair share of constitutional rebellion. Presidents have tried to curb their prime ministers, who is turn have had to confront their party's colleagues, and legislature. Speaker of the legislature have not only threatened but created crisis. Legislatures have claimed unlimited privileges. Judges have constantly rewritten the constitutional text to successfully claim powers never intended for them. Election commissions have flexed their muscles. The federal system is constantly renegotiated, with state democracy being undermined by the imposition of the union's president rule. Indeed, India went through a draconian emergency 1975 to 7 through an abuse of constitutional provisions when every check and balance seemed to fail except the power of the people, which threw Mrs. Gandhi's regime out of power in 1977 to return her back to the power in 1980. Generally, constitutional skirmishes and rebellions are not necessarily destructive of the constitutional fabric, but they can be. The Indian constitution has been put at risk as a result of the policy of maximization, with the consequences that each constitutional player sometimes has maximized its understanding of the use and abuse its own empowerments at the cost of developing working ground rules, institutional practice, and conventions. As I remarked when closing a now dated study of president's rules, the ground rules of Indian political system as they are constituted today work on the theoretical assumptions that every sectional interest in India can be politically effective if it uses the political and constitutional structure expediently, ruthlessly, and without obeisance to the operational morality that the parliamentary system envisages. This theoretical assumptions test on the premises that various interests seek a quick translation of their ambitions and the frustrations into political reality, even if this means breaking existing conventional norms of the political behavior. This idea of the quick translation of aspirations into reality induces a certain speed into system. The political system begins to reflect every twist and turn of the political behavior instead of stabilizing itself. And in time, the system itself, having compromised all its ground rules, begins to weaken unless some alternative rules are found to replace the previous ground rules. India today has compromised to existing ground rules without providing an alternative. Yet the Indian constitution had creatively muddled through tension, so it is still not secure from both constitutional lawlessness and the collapse of the rule of law, which threatens India's governance as a whole. The struggle for judicial supremacy is concerned with the tension between the political and justice text of the constitution. The political text constitutes how political power is institutionalized, distributed, and exercised. They set up the parliamentary and federal system to create political rulers. The justice text creates judicial custodian who ensure that constitutional empowerments stay within their design bounds, interpret and defend the Bill of Rights, resolve federal disputes, and the generally binds all rulers, great and small, within the rule of law. Judicial custodians were generally expected to behave conservatively, with due deference to exercise of power by the political rulers, and its, if needs be, interpret constitutional texts and doctrines harmoniously rather than use of their awesome power to strike down governmental action or legislation as unconstitutional. When the constitution began its journey in 1950, Nehru was convinced that the voice of the people and the democracy, history, and justice spoke through him and his government, both for now and the future. Given the Congress antecedents, he could not be grudged this winning admiration and support, but he was a vacillating ruler seeking to evolve a working consciousness which paid due deference to the political and the therefore political democratic power vested in himself. The judiciary was simply there to get on with its job without creating a fuss to defy the unraveling of India's history. Nehru had a clear concept of law and development, borrowed from the mixture of the Soviet planning, American New Deal bureaucratic regulation, the English Fabian socialism. Why which law was to instrument social change, albeit through tough controls and sanctions. In retrospect, such instrumentalism appears crude, but It was the fashion of the day and is still not entirely irrelevant to India, even if not to complete a faith cannot be reposed on it. By contrast, the judges of the Supreme Court of the 1950 had no constitutional philosophy as such, no distinct approach, no real disquiet with the law and development approach, but a sense of enormous power that they possessed in a way ways and to an extent not possessed by any other constitutional functionary. There were some libertarian, Fazal Ali, Bose, Mahajan later, Subba Rao, and possibly Hidayatullah, some conservative, Sastri and Chandrasekhar Iyer, possibly Mukherjee, and some pragmatists like S.R. Das and later Ganjendra Gadkar, uh, who wanted to quell confrontation, but these positions were often fluid. This resulted in an inconsistent and untidy approach as the judges cautiously and in the different ways tested the temperature of the water. Three rebellion. First rebellion 1915-1955. Till the emergency, Supreme Court, broadly speaking, posed three rebellion. The first rebellion, 1950, would generally have gone unnoticed if it had confined itself to claiming the power of judicial review and issues related to the personal liberty. The court had agreed to a narrow due process, accepted administrative preventive detention with limited judicial intervention, upheld the regulatory state, permitted vast delegated legislation, and generally allowed differential criminal procedures by speedy trial. They struck down certain public orders, statutes which infringed on the press freedom, necessitating a constitutional amendment, but generally relented on all fronts. If so, what went wrong? The fly in the ointment was the courts striking down land reform legislation aimed at directly wiping out the old jamidars and created at least new kulaks with some benefits to the peasantry. This was Nehru's dream from his earlier days in UP and part of the Congress political statement since at least the Karachi Resolution of 1931. Several high courts had rebelled. That was enough for Nehru to react. And the Supreme Court emerged the figure of M.C. Mahajan, one person judge from the federal court and the later to become Chief Justice of India. Had two judges succeeded in their endeavor, India's exchequer would have been bankrupted. No less, its radical image of the abolishing bestics of feudalism would have been tarnished. Along with others, the Supreme Court fought for higher market value compensation for the landlords. The middle class background of the judges began to reveal itself as they drew support from the Anglo-American theories of eminent domain, requiring full compensation for all required property. The more the Supreme Court fought, the stronger the response of the Nehru's parliament, which kept amending the constitution to reverse court decision. Mahajan and his colleagues were at the receiving end. This was a real crisis. Nehru even contemplated ignoring the seniority principle to Sikhs. Perhaps Roosevelt liked to bypass and supersede the claims of the Mahajan and others to become Chief Justice of India. But the informal story is that all the judges of Supreme Court threatened to resign if such a supersession took place. Constitutional amendments, supersessions, threats, public or oblique, all this and more. Such a battle had not taken place in the common law judiciaries since the 17th century. Nehru's onslaught was not simply that the judges had, as he put it, purloined and the constitution, but stood in the way of the nation's progress. Eventually, the judges simply backed off, but gracefully, without wholly surrendering their powers of the judicial review. The onslaught had been too great. Mahajans was sent off to hear some privy council's appeals in the Hyderabad. Chief Justice Sastri gave a speech on his retirement that the judges had been misunderstood. Many decisions were reworked. Some of the libertarian simply retired by the mid of 1950s. The first judicial rebellion died down. The first judicial rebellion of the 1950 had a very disquieting effect on the judges, forcing introspections. After all, who were the judges? Were they playing Anglo-American hopscotch with the Indian constitution, unmindful of the tasks that lay ahead? What was wrong with the Nehru's law and development approach? Did Indian judges not have an Indian response to an Indian situation? Apart from the strategic retreat of backing off whilst retaining their power of judicial review, judges begin to look for Indian answers for the Indian situation. Two significant responses emerged. The first was the role of the Supreme Court as problem solver. Controversies abounded. These included the Kerala Education Bill crisis 1958, the cow slaughter cases 1958 to 61, issue relating to the press 1958 to 62, UP High Court legislature crisis 1964, controversies over religious endowments 1954 to 64, on the power within the face of excommunication 1959. This problem solving functions continues. Without abandoning issues of the principle, the Supreme Court struck balances which would diffuse the issues and sought pragmatic answers. The second response of the sum of the judges was to broadly embrace Nehru's law and development approach. These judges saw themselves as a part of the task of the social engineering. To begin with, they had to move away from the image that judges stood in the way of progress. Hence, Justice Krishna Iyer's protest that judges were not to be seen as anti-catalysts. Many High Court judges took a similar view, but the towering exponent of the social engineering, borrowed from the no less towering American jurist Roscoe Pound, was Justice Gajendra Kadkar, Chief Justice 1964 to 6, who brought the court together on many issues concerning labor and workers' rights, the welfare state, and the secularism. And in a sense, the second response was akin to the first problem-solving response, but it added ideological purpose to juristic exercise. It also created a new concept of committed judges, seeking to separate those committed to the constitutional or was its regime goals from those who did not. The second rebellion, 1960 to 1971. By this time, the second rebellion was underway. It is very easy to regard these rebellions as intra-governmental palace rebellions led by the individual person and judges. In a sense, they are, but judges are part of the politics of the day. India's mixed economy yielded mixed responses. Within the Congress itself, there were powerful voices protesting landed and corporate interests. The judiciary is a natural location of establishment war. Even if just falter, lawyers and the interest they present keep chipping away. Even if the first rebellion had eventually yielded a set of Nehruvian judiciary, not everyone was happy with it. The legal establishment was divided. Lawyers like Palkhiwala and judges like Subbarao tried to rework the juristic laws of 1950. The first thrust was to generally try and enlarge the meaning of due process and the broad sweep of life and liberty and property. Provisions to this was added the fight over compensation for acquired property. All of a sudden, a debate that had been closed by the constitutional amendment of in 1954 was revived. This was done by the clever arguments of and twists of the meaning. Parliament's threat to rewrite the constitution was struck down by the slim 6 by 5 majority in 1967 to succeed it more fully in the third rebellion that was to follow. But these were rendered perspective so that the constitutional amendment of the past hurt only the government's political plans for the future. Meanwhile, in 1969, the Congress split into two socialist and capitalist house, with Mrs. Gandhi's Congress bringing in bank nationalization and the abolition of privy purses on her agenda. The bank nationalism case and to the larger extent the privy purses culminated was led. The compensation debate ended partially against the government along with the Times of India newsprint case 1972. The Supreme Court overcome its earlier inhibition to take an oppositional stand against the government. The second rebellion of the Supreme Court had distinct feature of its own. Unlike the first rebellion, it had been taken to its logical conclusion. Some of the judges of Supreme Court had not only taken the government on but also threatened to do so in future. No doubt the court was divided, but the posture of the Supreme Court bent violent threat into opposition. If the present pattern of the judicial appointment was to be continued, the opposition of the Supreme Court would increase, just as Mahajans was a key factor in the first rebellion to unite the libertarian Justice Subbarao and the Shah, possibly Hidayatullah, and no less significantly later Hayes were seen as the incoming tide of the opposition. The second rebellion was over many things, no less the philosophy of the constitution and the role of the judiciary. At the root lay the old issue of empowerment. Nehru and now his successor claimed the power to effect social change without being distrusted by the reactionary eyes of Jesus. If the Prime Minister was the democratic leader in the charge of the socialist constitutions, who were the judges to disabuse that position and the challenge his authority, the second rebellion was the unrelenting. Like Nehru, Mrs. Gandhi could have let it go and let things work themselves out, but she had decided not to do so. Like Nehru, she was going to use the power of constitutional amendment to undermine the existing and future judicial decision. Unlike Nehru, she had decided to take on the judiciary fully and put it in its place. The third rebellion, 1972-1975. It was Mrs. Gandhi's action that prompted the third rebellion to climax. The power to make judicial appointments continued to lie with the Prime Minister, with inputs from the judges. The final say lay with the Mrs. Gandhi. On advice, she cited several people who would be in the court for a long time for appointment. In this list were prominent names like Justice Chandrachud, Dwivedi, Bhagwati and Krishna Iyer, and other such as Ray and Beg. Krishna Iyer had been part of the first communist government of Kerala 1957 to 9, which Mrs. Gandhi had personally pressured Nehru to death throne by the use of president's rule. Her left advisor wanted Krishna Iyer but were apprehensive about him. He was appointed first to the Law Commission on some spurious regions invented by the Mohan Kumar Mangalam, one of the Mrs. Gandhi's advisors. Later he joined the Supreme Court in 1973 by this name. The remaining judges had already been appointed, with the politics playing its inevitable role in the timing of the respective appointment. In this way, she secured ballast for the future. From 1977 to 1986 onward, the Chief Justice of India would be chosen from her list. To all intents, she had a socialist court which would at least do her ideological bidding. The law minister could act as go-between, but in between lay a shadow. There were a series of chief justices in between. Hidayatullah, 1968 to 70, who had struck down constitutional amendment prospectively in 1967. Shah, 1970, who wrote the majority bank nationalization judgment. Sikri, 1973, who was a part of the rebellion but otherwise described as a forbearing gentleman. Selt, Hatch and Grover, the chief justice from the 19 73 in quick succession. Who would control the court after they were appointed? The future had been taken care of, but what about the present? And in 1972, Mrs. Gandhi's constitutional amendment sought to reverse the compensation jurisprudence of the bank nationalization case. 1970 post many states by judicial review and make it clear that if Parliament amended the constitution, courts could not strike this amendment down. Meanwhile, Mrs. Gandhi got a jolt in the Times of India case 1972 when Justice Sikh could rely on struck down her attempt to control the newspapers by rationing the newsprint on which papers are printed and subjecting them to direct governmental regulation, even if this was seen as hiccup. In 1973, an emboldened Supreme Court made its famous ruling in the fundamental rights cases that the basic structure of the constitution was to inviolate even from the constitutional amendments. The judgment itself makes dull reading. However, few can deny that it is one of the momentous constitutional rulings of all time. The judges had blocked Parliament's sovereign power and claimed to share the constitutional powers to remold the constitution. No changes could alter the basic structure of the constitution. The judges would decide what the basic structure was. They now control the constitution and any change to it. After third rebellion recorded its more than partial victories, Mrs. Gandhi, the recent victor of the Bangladesh war and the landslide victory that followed, struck back. Her chosen appointees, especially Chanchur, Ray Beg and Dwivedi, had been loyal to her even in the fundamental right case 1973. She wanted socialist judges.